Hello friends, welcome to our ExamBee's Law channel Legal+. We have started 300 most important law question series, and in this video we are going to discuss part 10, in which we are going to discuss questions from Law of Torts and Consumer Protection Act. We are soon going to end this series. There are total 15 videos in this series, and if you have any special request, you just have to write down your request in the comment below. In this video, we are talking about Law of Torts and Consumer Protection Act. In our next video on 2nd of December, we will discuss important questions from securities law. So starting with the first question, tort is statutorily defined under. The correct answer is Limitation Act. Tort is defined under section 2M of the Limitation Act as tort means a civil wrong which is not exclusively the breach of contract or the breach of trust. Law of torts is a common law, but definition of tort is provided under the Statute of Limitation Act. Question 2. Law of torts provides for a remedy. The correct answer is in case of breach of duty or for unliquidated damages. In case of breach of trust is wrong. Action under tort law can be instituted in case of breach of duty and for unliquidated damages. Actions arising out of breach of contracts and breach of trust are not covered under law of torts. As per the definition given by Salmond, a tort is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of a contract or breach of trust or other merely equitable obligation. Winfield, on the other hand, opined, tortious liability arises from the breach of duty primarily fixed by law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. Question 3. The idea of law of tort was taken up by. The correct answer is A and D. The idea of law of tort was taken up by Winfield. As also seen above, this theory proposes that all wrongs be considered a tort and liability should arise out of all if no lawful justification for it can be provided. Here Winfield had transformed his theory into a tree, saying that as branches of a tree grow and spread out in various directions, similarly law of tort expands with the society and cannot be confined into a single space or wholes. Winfield's theory also got immense amount of support by various judges. For example, in case of Ashby versus White, Justice Holt said that if a man multiply injuries, actions must be multiplied too. So every man who has been injured must be compensated effectively. Similarly, Pratt and Pollock also supports this theory of law of torts. Question number 4. A was a teacher in B's school, but due to some dispute, A set up a rival school to that of B's school, with the result that B was required to reduce the tuition fee of his school as the students from B's school shifted to A's school as he was popular among the students for his teaching. B sued A for monetary loss caused. What will be the result of this case? The correct answer here is B will not get any relief. He will get no relief. This situation is similar to that in the famous case of tort law, which was Gloucester Grammar School case. In this case, the defendant was a teacher in plaintiff's school, but due to some dispute, he set up a rival school to that of plaintiff's, with the result that the plaintiff was required to reduce the tuition fee of their school as the students from plaintiff's school shifted to defendant's school as he was popular among students for his teaching. The plaintiff sued the defendant for monetary loss caused. It was held that plaintiff had no cause of action against the defendant on the ground that bona fide competitions cause no action, whatever damages it may cause. Compensation cannot be granted as there was no infringement of any legal right. So a situation where damage is caused without any legal injury is known as damnum sine injuria, which means injury caused without any actual loss. So a person who suffers damage without any legal right being violated is not entitled to compensation. Question 5. What is the meaning of Nova Actus Interveniens? The correct answer is New Intervening Act. New Intervening Act, that is Nova Actus Interveniens, is a Latin maxim that stands for New Intervening Act. Nova Actus Interveniens is an independent event which, after the wrongdoer's act has been concluded, either caused or contributed to the consequence concerned. Thus, an intervening act leads to a breakage in the cause-effect relation of the act that harmed the plaintiff. It is used as a defense by the defendant to negate or reduce his liability. Question 6. Liability would exist irrespective of any fault. This is the principal witnessed under which of the following theories? The correct answer is all ABC. No fault liability, strict liability, absolute liability. In all of the above things, this theory is witnessed The concept of strict liability in torts is also referred to as no-fault liability, which can very well explain this concept in an obvious manner, that liability would exist irrespective of any fault. There exist certain activities which are inherently so dangerous in nature that merely carrying them on poses a duty on the person who does so to compensate for any damage irrespective of any carelessness on their part. The rationale behind imposing such liability is the foreseeable risk involved in such activities. Then absolute liability is a tort derived from British concept of strict liability with some changes. But the basic principle of no-fault liability exists in this theory as well. It does not give any exception to the defendant to save himself from the wrongful act, which is not the case in strict liability, as it leaves room for the defendant to save himself by proving that plaintiff was the wrongdoer, it was a major act of God, it was act of third party, or that there was consent. So on any of these reasons, in strict liability, the defendant can save himself, but in absolute liability, he cannot save himself. Question 7. Vicarious liability follows the doctrine of. The correct answer is respondeat superior. The vicarious liability follows the doctrine of respondent superior, that is the responsibility of a superior for the act of its subordinate. One of the most common forms is the imposition of liability on the employer for the acts of his or her employee. To be more precise, a master is liable for the acts of his or her servant. Question 8. Contributory negligence is. The correct answer is a defense to negligence. Contributory negligence, when a tort or wrongful action is committed by negligence on part of both the parties, the plaintiff and defendants, the defendants can raise the plea of contributory negligence under law of torts. It was common law rule that anyone who by his own negligence contributed to the injury of which he complains cannot maintain an action against another in respect of it, because he will be considered in law to be author of the wrong. Question number 9. Institution of false criminal proceeding against an individual that are motivated out of malice and are not supported by any element of reasonability or probability is. Correct answer is malicious prosecution. Malicious prosecution under law of torts refers to the institution of false criminal, bankruptcy, liquidation proceeding against an individual that are motivated out of malice and are not supported by any element of reasonability and probability. Question number 10. What does the word legal injury mean? The correct answer is violation of a legal right. A legal injury occurs when a person suffers a legal damage instead of actual loss. His legal right is infringed by some other individual. Question number 11. What is the full form of CCPA under Consumer Protection Act? The correct answer is Central Consumer Protection Authority. Under the Act of 2019, a Central Consumer Protection Authority was established with a view to regulate matters involving violation of consumer rights, misleading or false advertisements, unfair trade practices, and enforcement of consumer rights. The central government will appoint the members of CCPA. The authority will consist of a chief commissioner along with other such prescribed members. Question number 12. When consumer disputes come before a district consumer forum, it can refer the dispute for. The correct answer is mediation. If it appears to the consumer dispute redressal forum that the consumer dispute can be settled by way of mediation, it may refer the parties to mediation with their consent. For the purpose of mediation, state government shall establish a consumer mediation cell for each district commission and state commission. The central government shall establish a consumer mediation cell attached to the national commission. The consumer mediation cell will be responsible for maintaining a list of empaneled mediators, cases handled by the cell, record of proceeding and other information by specified regulations. The cell also has to submit a quarterly report to the commission it is attached to. Question number 13. What is the penalty for making a false and misleading advertisement as per Consumer Protection Act 2019? The correct answer is imprisonment or penalty up to 10 lakh rupees as given under section 21 subsection 4 of the Act. Any person who publishes false and misleading advertisement may be punished with imprisonment or penalty that may extend to 10 lakh rupees. Question number 14. What is the limitation period for filing a consumer complaint for defect in goods or deficiency in service? The correct answer is 2 years. This is given under section number 69 of Consumer Protection Act. The District Commission, State Commission or National Commission shall not admit a complaint unless it is filed within 2 years from the date on which the cause of action has arisen. Question number 15. What is the pecuniary jurisdiction of a state commission? The correct answer is 1 crore to 10 crores. As per the Consumer Protection Act, section number 47, the State Commission shall entertain complaints where the value of goods or services paid as consideration exceeds rupees 1 crore but does not exceed rupees 10 crores. For District Commission, it is less than 1 crore, and for National Commission, above 10 crores. Question number 16. The National Commission shall consist of, the correct answer is President and 4 other members and maximum as prescribed by the rules. This is given under section number 54. The National Commission shall consist of a President and not less than 4 members, not more than such members as may be prescribed. Question number 17. The Central Council shall have at least how many meetings in a year? The correct answer is 1. At least 1 meeting should be there. This is given under section number 4. The Central Council shall meet as and when necessary, but at least 1 meeting of the Council shall be held every year. Question number 18. Consumer Protection Act 2019 is applicable to. The correct answer is all goods and services except as expressly provided by the central government by notification. This is given under section number 1 subsection 4. Save as otherwise expressly provided by the central government by notification, this act shall apply to all goods and services. Question number 19. What is e-commerce? The correct answer is e-commerce means buying and selling of goods and services including digital products over digital or electronic network. In this question, you can find more than one answer to be correct, but you will have to mark the most accurate answer here. This is given under section 2 subsection 16 in the definition of e-commerce. Question number 20. Spurious goods are. The correct answer is those goods which are falsely claimed to be genuine. This is given under section 2 subsection 43. This was the last question of this video series. In our next video, we'll be discussing important questions from securities law. I'm again saying, if you want questions from any particular act, you want revision of any particular topic, then mention that in the comment below. Apart from that, if you have any other queries, if you have any doubts, you can also mention them in the comment. We are starting a new batch for SEBI Legal from 1st of December, for which I have already shared a 50 days class schedule starting 1st of December. Following this class schedule, you can cover up your syllabus till 21st, 22nd of January, and we are hoping the SEBI Legal Phase 1 exam either on 25, 26, 27 January. So this new batch is very much useful for you. In this, there will be extensive revision and concept clarity in the classes, and you will get a lot of practice questions. So you can check out our SEBI Legal course, and you can download the study plan from our YouTube channel and also our Telegram channel. Subscribe to our Legal+P YouTube channel. This is a one-stop solution for all legal exams. If you need any guidance, if you have any queries, you can also reach out to us on this number. Thank you.